It's a fairly high-density gym zone up here. That's purely coincidental. It is, I suppose, obvious that there is no area of law in which the interplay and interaction between law and politics is more apparent than generally in the field of constitutional law. And if that's true, generally, it is equally true that there's no area of constitutional law in which the interplay and interaction between law and politics is more apparent than in the field of law dealing with the relationships between the Crown and Indigenous peoples. And without wanting to belabor this too much, if that's true, there's no area of constitutional law dealing with the relationship between the Crown and Indigenous peoples in which the interplay and interaction between law and politics is more apparent than the field of law that informs, leads to, and governs the entering into and implementation of modern treaties. Of course, the relationship between the Crown and Indigenous peoples is, like all relationships, inherently and necessarily political. And of course, the negotiation, settlement, ratification, and implementation of modern treaties is necessarily political. But the politics is inextricably related to, informed by, shaped, and given effect by the legal rules and principles that govern the relationship between the Crown and Indigenous peoples that are enforced by the courts. They give the background, they give the context, they give the ground rules to the ongoing task of implementation of modern treaties. In the time available this morning, I'd like to take the opportunity to identify and say a few words about the state of the law coming out of the courts that is specifically concerned with modern treaties. And before I do that, it's worth emphasizing that, of course, all of the main legal principles applicable to the Crown-Indigenous relationship that apply generally, of course, apply in the context of modern treaties as well. It's also worth emphasizing that 14 years ago, when the coalition was formed, there didn't yet exist a body of law that was dealing specifically with the interpretation, nature, and effect of modern treaties. There is now an emerging body of law that is setting forth what modern treaties are and how they fit into the Canadian legal system. That's a good thing in a way. It's unfortunate in a way. I say it's unfortunate only because you only end up going to court when there have been disputes. So the fact that there's an emerging body of law is the result of the fact that over the course of those 14 years, people were obliged to go to court to settle their disputes. You know, my first couple of months of law school, somebody passed around a cartoon. I'm sorry, has nothing to do with anything, but just disputes reminded me of it. And the cartoon was called The Dispute. And there was a picture of a cow, and on one end of the cow, there was a person pulling the cow by the head, and on the other end, the person was pulling the cow by the tail, and in the middle was a lawyer who was milking the cow. I don't want to say that that influenced my entire approach to law ever since, but it's worth noting. Courts only get involved and pronounce on the law when there is a dispute. That's right, but that has political effects. So as Jim just mentioned, of course, the Calder case in 1973 was the result of a dispute as to whether or not Aboriginal title continued to exist, and the Nisga'a took the Attorney General of British Columbia to court, resulted in the Calder decision. That's a legal development, but the political consequence was the establishment by the federal government of the so-called comprehensive land claims policy that led to all the modern treaties. Similar interaction happened, of course, with the James Bay Northern Quebec Agreement, which was, in fact, an out-of-court settlement of a lawsuit brought by the James Bay Cree against the hydroelectric projects. There's this interaction, a mutual informing of law and politics that sets out and defines what we're all doing here today. Now, I mentioned that since the 2000s, there's now an emerging body of law. I'm just going to go through a bunch of cases and read a few things that, to the best of my ability, summarize the state of the jurisprudence as to the nature of modern treaties. The first case I'll refer to is a decision of the Supreme Court of Canada called Quebec versus Moses, 2010. For those of you who care, 2010 SCC 17. It was a decision made in May of 2010, and it was a dispute that really involved the relationship between the federal and provincial environmental legislation in light of the James Bay and Northern Quebec Agreement. And during the course of deciding whether or not federal jurisdiction had been limited by the treaty, the Supreme Court of Canada pronounced for what I believe to be the first time on the nature of modern treaties. Writing for the majority, Justice Binney observed, and I quote, he said, "In Regina versus Badger, Corey pointed out that Aboriginal treaties are analogous to contracts, albeit of a very solemn and special public nature. At issue in that case was an 1899 treaty. The contract analogy is even more apt in relation to a modern comprehensive treaty, whose terms, unlike in 1899, are not constituted by an exchange of verbal promises reduced to writing in a language many of the Aboriginal signatories didn't understand. The text of modern treaties is meticulously negotiated by well-resourced parties. The importance and complexity of the actual text is one of the features that distinguishes the historic treaties," he meant historical, "made with Aboriginal people from the modern comprehensive agreement or treaty of which the James Bay Treaty was the pioneer. We should therefore pay close attention to its terms." Now let me pause. Very important concept going on in that passage that I just read. It's recognizing one of the three facets, or aspects, or faces, or ways of looking at modern treaties. Modern treaties are contracts, entered into by, as the court said, well-resourced parties who meticulously negotiate its terms, and they have the force of contract. I should pause and say that modern treaties are also statutes. They're statutorily ratified, they're given the force of law, they're made binding on the world, they're not simply contracts between the parties, they're part of the law of the land. That's the second aspect. And the third aspect is that they are constitutional instruments that inform and govern the country at the constitutional level as well. And that point is picked up by the minority in Moses, who dissented about the particular terms governing environmental assessments, but the observations they made about the nature of modern treaties were not any different than what was said by the majority. And Justices Lebel and Deschamps said in part, "The agreement is both an intergovernmental agreement and an Aboriginal rights agreement." It has those two aspects. "It is binding upon and creates rights and obligations for the federal and provincial governments and the First Nations. It may be viewed as a model for the many modern land treaties that have been signed since the 1982 constitutional amendments, which included the protection of what are now referred to as modern treaty rights under Section 35(3). They continue, "The agreement is far more comprehensive in scope than either the treaties of peace and friendship," Jim talked about, "or the numbered treaties considered by this court in a number of cases in which the analytical framework for interpreting the historical treaties between certain First Nations, Canada and Great Britain was developed." They then quote Professor Sébastien Gramont, who said that modern treaties tend to address far more than just the ceding of territory. Professor Gramont said in the passage approved, "Modern treaties therefore cover a much wider range of subjects than the territorial treaties of the 19th century. In modern treaties, the Crown and Aboriginal peoples have tried to specifically define the rights and obligations in many areas, such as land use, hunting, fishing, sharing of royalties for the use of natural resources, environmental assessment, economic development, preferential hiring, awarding of contracts, adaptation of public services. The most recent agreements also include provisions on self-government, dispute arbitration, and coordination with the claims of neighboring Aboriginal peoples." The minority says this agreement, referring to the JBNQA, fits this description well. It establishes a comprehensive legal framework setting out the parties' respective responsibilities where services and rights to land are concerned, and organizing their relationships for the future. It's one of the ways in which modern treaties are unique. They're different from the historical treaties because of their breadth, but they're also quite different from much narrower agreements, such as exist, for example, with groups that have a self-government agreement, but not a modern treaty. That deals with an important facet of the relationship, but what the court is stressing about modern treaties, comprehensive land claims agreements, is their breadth. They seek to inform and specify the nature of the relationship in myriad different ways. The next case I want to tell you a little bit about is called Beckman versus Little Salmon Carmacks First Nation. Came out of the Yukon, 2010, Supreme Court of Canada 53. And the issue in that case was whether or not the Yukon final agreements exhaustively set out the Crown's duty to consult if the Crown was going to take actions that would adversely affect, that did adversely affect, the treaty rights. In other words, is the modern treaty a complete code that excludes other fundamental constitutional principles and only includes the things that are specifically and expressly referred to in the agreement? That's what the Crown argued. And ultimately, people are no doubt aware, the Supreme Court of Canada said that there is an ongoing common law duty to consult with Indigenous people if the Crown proposes actions that may adversely affect a treaty right. And it's not exhaustively set out within the four corners of the agreement, that there's a common law constitutional framework within which the treaty was negotiated, which continues to apply. What the court's observations along the way, and this is again Justice Binney, said, and I quote, "Unlike their historical counterparts, the modern comprehensive treaty is the product of lengthy negotiations between well-resourced and sophisticated parties. The reconciliation of Aboriginal and non-Aboriginal Canadians in a mutually respectful long-term relationship is the grand purpose of Section 35 of the Constitution Act. The modern treaties, including these at issue here, attempt to further the objective of reconciliation, not only by addressing grievances over land, but by creating the legal basis to foster a positive long-term relationship between Aboriginal and non-Aboriginal communities." And then he speaks directly to the officialdoms that implement treaties. And Justice Binney wrote, "Thoughtful administration of the treaty will help manage, even if it fails to eliminate, some of the misunderstandings and grievances that have characterized the past. Still, as the facts of this case show, the treaty will not accomplish its purpose if it is interpreted by officials in an ungenerous manner or as if it were an everyday commercial contract. The treaty is as much about building relationships as it is about the settlement of ancient grievances. The future is more important than the past. A canoeist who hopes to make progress faces forwards, not backwards." I want you to know we all appreciated Justice Binney's helpful nautical tip. But the important part of that paragraph is referring to, yes, it's a contract, but it's a contract that has to be interpreted in a way that achieves its purposes. It can't be interpreted in an ungenerous way or with mere attention to the strict, literal, technical interpretation of its terms. Justice Binney continues, "The increased detail and sophistication of modern treaties represents a quantum leap beyond the pre-Confederation historical treaties. The historical treaties were typically expressed in lofty terms of high generality and were often ambiguous. The courts were obliged to resort to general principles such as the honor of the Crown to fill the gaps and achieve a fair outcome. Modern comprehensive land claims agreements, on the other hand, starting perhaps with the James Bay and Northern Quebec Agreement, while still to be interpreted and applied in a manner that upholds the honor of the Crown, were nevertheless intended to create some precision around property and governance rights and obligations, instead of ad hoc remedies to smooth the way to reconciliation. The modern treaties are designed to place Aboriginal and non-Aboriginal relations in the mainstream legal system with the advantages of continuity, transparency, and predictability. It is up to the parties when treaty issues arise to act diligently to advance their respective interests. So the concept of acting diligently when issues arise is fundamental to the continuity, transparency, and predictability. Justice Binney continues, good government requires that decisions be taken in a timely way. That's a useful hope. To the extent that territorial government argues that the Yukon treaties represent a new departure, I think it's correct. However, as the trial judge Vale J. aptly remarked, the new departure represents but a step, albeit a very important step, in the long journey of reconciliation. Treaties don't finish reconciliation. Reconciliation isn't something to be achieved and now it's over. We have reconciled. Reconciliation is a process, a continuing journey together that's supposed to be done within the relationship as defined by the modern treaties, but being renewed and built upon day after day after day in a way that reflects the parties' diligence and intention to achieve the objectives. The next cases that I want to talk about briefly had to do with one of the big changes that happened in modern treaties that took place with the Niska Treaty, in fact. Niska Treaty was the first modern treaty to actually include within its terms all of the detailed rules governing Niska government or self-government. All of the modern treaties since the Niska Agreement have done so as well, but the Niska Agreement was the first one to do that and to give them constitutional protection. And many people may recall the outcry, nay, dare I say, the hysteria in certain quarters of the land at the idea that Indigenous people might actually have constitutionally protected self-government. And people might recall that the Niska Treaty was taken to court by the then leader of the opposition in British Columbia, Gordon Campbell, who went to trial and did not succeed, of course, and then he became premier, and then he discontinued the action. But some others picked it up, some Niska individuals supported by lawyers, who wanted to pursue the question of whether or not the self-government provisions of the Niska Treaty were unconstitutional. And in arguing the case, one of the things that struck me was ironic, is they seemed to be saying, we can make a promise to you that you can govern yourselves, but if we can't break that promise, then it's unconstitutional. We will only make you this promise on the basis that we can break our promise. That's okay. Right? But as soon as you say, no, the Crown can't break its promise, no, that's unconstitutional. Very strange view of the universe. Anyways, rejected. And it was rejected at trial, and then the matter proceeded to the British Columbia Court of Appeal, who, of course, upheld the Niska Treaty. And the application for leave to appeal to the Supreme Court of Canada was denied. So that leaves the Court of Appeal decision in place. It was in February of 2013. And the British Columbia Court of Appeal, in responding to this idea that somehow giving constitutional protection to the self-government terms of modern treaty is unconstitutional, replied by saying, I quote, "The treaty is a complex, detailed, and comprehensive agreement addressing all aspects of the continuing relationship between the Niska Nation, Canada, and British Columbia, as well as the powers of Niska government to make laws in relation to matters vital to the Niska, including the preservation of Niska culture, language, and education, lands and resources, and other matters integral to the continuing viability of the Niska Nation as an Aboriginal people within Canada. Importantly, for the purposes of this appeal, the treaty expressly recognizes that the Niska Nation has the right of self-government and the authority to make laws, as set out in the agreement. After discussing all of the arguments back and forth, the Court of Appeal concluded, I am unable to conclude that the combination of the treaty and settlement legislation breaches any constitutional prohibitions. The treaty has been carefully crafted to respect constitutional principle and to fit into the wider constitutional fabric of Canada. It is what it purports to be, an honourable attempt to resolve important but disputed claims, to achieve reconciliation, and to lay the foundation for a productive and harmonious future relationship between the Nisga'a Nation and the non-Aboriginal population of Canada. The themes continue to be repeated. Reconciliation is not a final product. The treaty sets the basis for the ongoing relationship. But as the Court of Appeal said of the Nisga'a Treaty, could equally be said about all of the other modern treaties. They are complex, detailed, meticulously negotiated, comprehensive agreements that fit totally within the constitutional fabric and nature of this country. The courts have repeatedly said that. The courts like the idea of modern treaties to set forth the basis of the relationship, because then they don't have to, and it's better for everyone. One of the cases that came along because of a dispute when things weren't going that well was an action that was brought by NTI in 2006 as a result of ongoing breaches of the Nunavut Agreement by the federal Crown. It was a very complicated lawsuit. It went on for a long time. It was ultimately settled, which is always a good thing. It's always better to settle cases than not to. But a very small part, but a significant part of the NTI lawsuit had to do with one of the enumerated 14 or 15 breaches, I don't recall now. It had to do with the requirement on the part of the Crown to to establish and conduct general monitoring, environmental monitoring as part of the planning process. And there was a particular provision of the Nunavut Agreement requiring that to take place, and the Crown just didn't do it, just hadn't done it. And there was a lot of reasons that were given and so on, but there was no question about it. The Crown admitted on discovery, no, we didn't do that. And after the action got going, then a few years in, the Crown and NTI sat down, and now it's going to start, and it was budgeted for, and that gave an estimation of the cost of actually carrying out the general monitoring. So it was kind of an unusual situation because there was both an admission of the plain fact of non-compliance and the possibility to do a calculation as to what the Crown had in fact saved by failing to keep its promise. The Crown had, in effect, pocketed the money that it would have spent had it kept its promise. And it was possible to calculate how much that was. So NTI brought on a motion for summary judgment on just that small part of the claim. And why I want to talk about that for a minute, there's a couple of reasons, but one is because it focused on the contractual nature of the treaty. Remember, I said treaties have these three faces: their contracts, their statutes, and their constitutional instruments. And often in litigation, the focus has been upon their statutory force or the constitutional force. The NTI lawsuit focuses on the contractual nature of the dispute. The thing is that in the Canadian legal system, the common law system in England, the United States, the normal remedy for breach of a contract is what they call expectation damages. In other words, if a plaintiff is able to convince the court that the defendant has breached the treaty, then the court makes an order to put the plaintiff in the position that they would have been in, so much as money can do, as if the contract had not been breached. It's called expectation damages. But in this case, it was very difficult to do that. Well, how much money is the failure over a period of time to conduct environmental monitoring, general monitoring, how much money would compensate us for that? And the argument that was put forward is you can't calculate that. But it would be unfair if all the Inuit got was nominal damages. Here's your dollar. We can't calculate it. Because we knew from the budgetary cost that over the period of that many years, the Crown had saved roughly $15 million. Put it in its pocket. So what we argued was that the special circumstances required a principle of what's called in law, it's a wonderful term, disgorgement to apply. It's good, isn't it? Disgorge. The Crown has to disgorge itself of the money that it received. Disgorgement is often a remedy for breach of fiduciary duty. I don't want to get into it in much detail, but it's very rare for breach of contract. In fact, disgorgement hasn't been ordered for breach of contract in Canada until this case. And when all of this was laid out and presented to the Nunavut court, the trial judge, or the Chamber's judge on the summary motion, said the following: "The Crown was indifferent to its obligations over many years and was only prodded into action by this lawsuit. Even then, it took almost 4 years before the money started to flow. Canada's breach was not an efficient breach because the Inuit are worse off while the Crown is better off. I'm satisfied," said the judge, "that Canada's failure to implement an important article of the land claim for over 15 years undermined the confidence of Aboriginal people, and the Inuit in particular, in the important public value behind Canadian land claims agreements. That value is to reconcile Aboriginal people and the Crown. It would be manifestly unjust to allow the Crown to benefit from its failure to fulfill its obligations. It is also important that to ensure that the Crown properly respects and fulfills its obligations under land claims agreements, including obligations to provide benefits that are not capable of being quantified in financial terms. NTI's motion for summary judgment is granted. I award NTI damages in the amount of $14,817,500. The Crown appealed, and it went to the Nunavut Court of Appeal, which is the Alberta Court of Appeal, more or less. And when it went to the appeal, ultimately, the Court of Appeal argued that it was not appropriate on summary judgment without a trial to settle on the amount of $14,817,500. That amount was derived from what the Crown government did budget when it started implementing the General Monitoring Plan, but the court said it's not clear that that's the number that should be used. There should be a trial on the quantum. But on the principle of whether or not the Crown can be forced to disgorge any money that it saves by virtue of its own breach of modern treaties, the Court of Appeal upheld the trial judge. And the Court of Appeal said this: "The appellant received," that's the Crown, "valuable consideration for the covenant," the promise, "to establish a system of statistical monitoring. If it could simply refuse to perform that covenant and argue that it need not pay any damages because none could readily be established, it would potentially deprive the Inuit of many of the intended benefits of the land claims agreement. In the context of a land claims treaty, insulating the contracting government from any consequences of a breach of a covenant like this is legally unacceptable. As a result, the case management judge was correct in concluding that the respondent is not limited to a claim for nominal damages. Some appropriate measure of damages must be found. The savings achieved by the Crown in not performing are different in character from the profits recovered in this case, but similar to those recovered in that case, and that's a relevant consideration." Now, the entire case was settled before there was the need for any court to look further at this. So this remains the state of the law, certainly in Nunavut, but I would say it's persuasive authority everywhere in Canada, that if the Crown breaches modern treaties, thereby saving money, and the saving cannot otherwise, or the damages cannot otherwise be calculated, then the principle of disgorgement would apply. Now, the cases that I've just talked about were all decided roughly between 2010 and 2014. There were other cases, the most significant one of which for this discussion is the Manitoba Métis Federation decision of the Supreme Court of Canada, in which the court underlined that in all constitutional obligations, whether to Indigenous people, whether they be based on treaty, whether they be based on provisions of the Constitution itself, as in the case of MMF, the Crown has an obligation to carry out its responsibilities diligently. That phrase was used earlier. So all of these cases came together, and I suspect I believe it to be the case that the combination of those lawsuits generally, the NTI lawsuit particularly, the statements of the Supreme Court of Canada, helped propel the previous federal government, with the very, very expert help of its officials in the implementation branch and elsewhere in the department, who need to be given credit for this, to adopt a statement of principles that President Clayton referred to in her opening comments in July of 2015. And those statement of principles that were developed collaboratively with members of the LCAC, as opposed to being developed unilaterally and announced, like the more recent statement of principles, really summarize the state of the jurisprudence, thereby once again bringing together the legal and the political in the way that I commenced my comments with. And that, in the context of the Cabinet Directive, establishes roughly where we sit today. And the rest of this conference will be dedicated towards how we build on that and move forward for the future, always remembering what direction the wise canoeist faces. Thank you very much for this.